On June 8, 1789, James Madison proposed his amendments offered in Congress in the United States. At the time, the Constitution received very staunch opposition against being ratified from several prominent figures, including some of our founding fathers. Why were they objecting to it, you might ask? Because according to them, it failed to protect the basic principles of human liberty. Madison's amendment sought out to address their concerns by establishing 12 articles in the Constitution that were intended to achieve 3 goals. That there be prefixed to the Constitution a declaration that all power is originally vested in and consequently derived from the people. That government is instituted and ought to be exercised for the benefit of the people, which consists in the enjoyment of life and liberty, with the right of acquiring and using property, and generally of pursuing and obtaining happiness and safety. And finally, that the people have an indubitable, unalienable, and indefeasible right to reform or change their government whenever it be found averse or inadequate to the purposes of its institution. Madison's articles were largely influenced by the Magna Carta, the works of the European Age of Enlightenment, the 1689 English Bill of Rights, and George Mason's Virginia Declaration of Rights from earlier in 1776. Out of those 12 articles, 10 went on to be amended to the Constitution, which ultimately led to its ratification, and would then go on to be known as the United States Bill of Rights. The first of those 10 amendments, at least in the modern day, reads as such: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. This is what we have written into law today, but what James Madison initially proposed was just a bit different. The people shall not be deprived or abridged of their right to speak, to write, or to publish their sentiments, and the freedom of the press, as one of the great bulwarks of liberty, shall be inviolable. The First Amendment is widely recognized as being our right to freedom of speech, and while it speaks directly to the duties and powers of the United States Congress, the article that James Madison proposed truly embodies the principle of freedom of speech. 11 years later, where do we find ourselves? In a situation where the left, the people whose politics should be fundamentally based in liberalism, the pinnacle of freedom and personal liberty, find it expedient to brand the expression of certain ideas as hate speech, and then to aggressively and undemocratically censor certain speakers on the grounds that they are offensive to the sensibilities of someone somewhere. We find ourselves in a situation where the very countries that the Age of Enlightenment took place in find it to be correct to turn their backs on those Enlightenment values that gave rise to the structure of Western liberal democracy, supposedly in favor of supporting multiple cultures and a variety of lifestyles. In the face of all this, as bleak as things may seem for the future, I find myself proud to say that here in the land of the free, following the guidelines set in the Constitution by James Madison and the Congress of 1791, the Supreme Court of the current year have drawn their line in the sand and said loudly, clearly, unambiguously, and unanimously that hate speech is free speech. The idea that government may restrict speech expressing ideas that offend strikes at the heart of the First Amendment. Speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. A law found to discriminate based on viewpoint is an egregious form of content discrimination, which is presumptively unconstitutional. A law that can be directed against speech found offensive to some portion of the public can be turned against minority and dissenting views to the detriment of all. The First Amendment does not entrust that power to the government's benevolence. Instead, our reliance must be on the substantial safeguards of free and open discussion in a democratic society. These are the words expressed by our Supreme Court when ruling on Mattel versus Tam, a case in which the government refused to register the slants as a band's trademark on the grounds that the name might be seen as demeaning to Asian Americans, and in an 8-0 ruling, this was found to be unconstitutional. The reason we're here to talk about this today is that the ruling is not only a victory for the slants, who I encourage everyone to buy at least one song from as a massive thank you for pushing this issue into the Supreme Court where the free speech of individuals could once again be fought for and won, but also that this ruling carries with it a legal precedence that specifically prohibits the behaviors of the radical left that we have seen, been negatively affected by, and fought against over the past 7 years. In the context of this event, our Canadian neighbors to the north have enacted a piece of legislation known as Bill C-16, an amendment to the Canadian Human Rights Act to add gender identity and gender expression to the list of prohibited grounds of discrimination. While the primary goal of this bill is not something I find contentious, as it is not in violation of the principles of liberalism, Bill C-16 also amends the criminal code to extend to the protection against hate speech set out in that act to any section of the public that is distinguished by gender identity or expression. What this means outside of legal jargon is that individuals may be punished for speaking to other individuals in a way that does not honor their gender identity or expression. And I'll let Dr. Jordan B. Peterson explain why this is in violation of the freedom of speech of your average Canadian citizen.
The issue with the law is quite straightforward. The government is requiring us to use certain language. That's not the same as not using certain language. And it's a line, and this is the fundamental issue. This is maybe the fundamental issue. That's a line we should not cross. We should not allow the government to decide which words we're allowed to use. It's a mistake. And it's a mistake that strikes right at the heart of free speech. And the thing about free speech is that it's not the right to criticize your leaders, which is what people usually characterize it as. Is freedom of speech is freedom to engage in the processes that we use to formulate the problems in our society, to generate solutions to them and reach a consensus. It's actually a mechanism. It's not just another value. And you should put constraints on free speech with the most extreme caution because you interfere with people's ability to think and communicate.
And it's this restriction to our ability to think and communicate that would render the less agreeable parts of Bill C-16 unconstitutional in the United States on the basis that they infringe upon the freedom of speech of the individual. While C-16 is part of the Canadian legislature, and as such is not affected by this Supreme Court ruling, there is a similar piece of legislation in the United States that, to the best of my knowledge, should have been rendered unenforceable on the grounds that it is now unconstitutional. Under the New York City Human Rights Law Administrative Code, engagement in discriminatory harassment, motivated by a person's actual or perceived gender identity or expression, is explicitly prohibited. Now, the next question is, how does New York define harassment? Under New York Penal Law 240.30, a defendant is guilty of harassment in the second degree when, with intent to harass, annoy, or alarm another person in or about public places, they engage in conduct or repeatedly commit acts which alarm or seriously annoy the victim and serve no legitimate purpose. So under this definition of harassment, that includes simply annoying an individual, this would consider intentionally not using the preferred gender pronouns of that individual not only harassment in the second degree, but also in violation of the New York human rights law. However, I'll refer you again to the statements of Justice Samuel Alito. The idea that government may restrict speech expressing ideas that offend strikes at the heart of the First Amendment. Speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. To the best of my interpretation of this ruling, both the New York definition of harassment and the provision in the New York human rights law prohibiting discriminatory harassment are unconstitutional on the basis that they infringe upon the First Amendment rights of the individual. As it turns out, citizens of the United States do not have the right to not be offended. What this ruling also means is that universities and schools that receive government funding are no longer able to prohibit hate speech on campus, because hate speech is protected free speech. This means that these places do not have the right to prohibit speakers from presenting ideas on their campuses based on their political views, their views on race, ethnicity, sex, gender, religion, age, disability, or any other similar ground that is considered hateful. And that no publicly funded institution may fire an employee on the grounds that they are racist, sexist, ableist, transphobic, or any other view set, because students and teachers have the same constitutional rights. The implications of this ruling go so incredibly far, but these are the things that immediately come to mind for me. Anyone's guess as to why that is. So with this monumental achievement in defending this modern liberal society we have spent hundreds of years crafting in the United States, from what can only be described as well-intentioned but ultimately oppressive ideas, we should take this opportunity, for just a moment, to look at those who do not understand freedom of speech, as evidenced by their words and actions that work to undermine it, and give them a hearty, "I told you so." To everyone who said that hate speech wasn't free speech, I told you so. To everyone who swears up and down that they have a right to not be offended, I told you so. And to everyone who makes it their objective to shut down the platforms of those invited to speak on public settings,
I told you. What did I tell you? Didn't I tell you? 'Cause I told you. And when did I tell you? A long time ago. And what did I say will happen when I told you? Exactly what just happened.
And finally, to our vowel-challenged redheaded cousin to the north, our beautiful, beautiful younger sister Australia, and most importantly, to dearest mother and her glorious waterlocked United Kingdom, along with the rest of Europe. The 3 countries I've named all have hate speech laws, prohibiting individual citizens from expressing certain viewpoints or ideas about race, sex, or religion. I'm sure that we are all familiar with the ongoing trial of Count Dankula, who is potentially facing jail time for pulling a prank on his girlfriend by teaching her pug to raise its paw when someone says "Sig Heil." And over in Canada, I believe many of you have heard the horror stories of the Canadian Human Rights Tribunal, which strips Canadian citizens of basic rights established over 800 years ago in the Magna Carta, which had become a core part of justice in the English-speaking world ever since its conception. And Australia, with this barbaric law that prohibits the denigration of certain people or religions in such a way where your ironically named Human Rights Commission must consider whether or not this harmless cartoon, which only exists as cultural criticism, is illegal on the grounds that it is insulting to Aboriginal people. Let me explain this again to the 3 of you. It is not a basic human right to not be insulted. It is not a basic human right to not be offended. And aside from fraud, slander, and coercion, it is not within the power of the government to control the speech of its citizens. You have all gone off the rails and forgotten what it means to be a Western liberal democracy. And until you can see where you've gone wrong and correct these issues, I suggest that you all sit back and take notice as America, the middle child, shows you what it means to be a nation that actually cares about the most basic human rights.